This is going to be the typical New Hampshire DWI process, both administrative and courtroom, with the reciprocal implications for a Massachusetts driver who's been arrested and charged in New Hampshire. So for purposes of this discussion, you need to understand that there are two processes that you need to go through. The first one I always refer to as the ALS. And ALS simply stands for Administrative License Suspension. And it's administrative because this suspension, if it applies to you, comes at you through the New Hampshire DMV. It has nothing to do with what's going on in the courtroom. Every state in the nation has an implied consent statute, and New Hampshire has one as well. The implied consent statute in New Hampshire states literally that if you drive a motor vehicle on the ways of New Hampshire and you've been arrested for a DWI offense, it is implied that you shall submit to a chemical test. Now, you don't have to, and you can exercise your right to refuse, but there are implications, administrative sanctions that apply. For purposes of this discussion, let's assume that you've been arrested on January 1st of this year. That's the date of your arrest. At the time of your arrest, you're asked to submit to a chemical test. It's either breath, blood, or urine, and it's the choice of the police officer, not you, which one is going to be submitted to. If you exercise your right to refuse to that test, your privilege to drive in New Hampshire or your driver's license, if you're a New Hampshire resident, is going to be revoked if you refuse the test. That revocation of your license kicks in or goes into effect 30 days after your arrest. So effective 30 days later, your license or privilege is going to be revoked because you refused to test. If you took a chemical test at the time of your arrest and the results of that chemical test are greater than a .08, then your license is also going to be revoked for a period of 180 days. And that period of suspension, again, begins 30 days after your arrest. What is important to understand is that if you are subject to this administrative suspension, you have a right to a full evidentiary hearing, some due process before the New Hampshire DMV. And if you have the pink suspension notice that they hand you at the time of your arrest, if you flip that pink piece of paper over, it sets forth your administrative hearing rights. At that hearing, it's a civil administrative hearing. They do not need to prove DWI, but what they do need to prove is that the officer had reasonable grounds to believe that you were in fact DWI. He has to explain the facts upon which those reasonable grounds are based. He has to prove that you were arrested, that you were informed of your administrative license suspension or implied consent rights, and that you either then refused the test or took a test resulting in a .08 or higher. If he does that at the administrative hearing, then the hearings officer is going to say that the suspension is affirmed. Now, in order to have that administrative hearing, you must request the hearing in writing within this 30-day window. So it's critically important that you have hired and retained an attorney before the 30-day window after your arrest closes. If you don't request the administrative hearing within the 30 days, you'll lose the opportunity to do that. Now, in my DWI practice, I ask for the administrative hearing in each and every one of my New Hampshire DWI cases. The result of those hearings is most often, and when I say most often, almost 90% of the time, the decision of the hearings officer, whether it's a refusal or a chemical test over, is going to be that I've affirmed the suspension. And then people say to me, well, Bowser, why do you do these administrative hearings if they result in the suspension being affirmed? The reason I do them in each and every case is because that officer, whether it's the arresting officer and the chemical test machine operator, they both need to appear, they have to be under oath, and they have to answer questions about your DWI arrest, including whether they had reasonable grounds to believe your DWI and the facts upon which they are based, which means I get to ask whatever questions I want on those two issues, and I'm certainly going to utilize that administrative hearing to prepare for the criminal trial that's coming. So I'll leave that hearing with a transcript, and I will utilize that transcript to assist me in the courtroom on the DWI charge. Now, if you're from Massachusetts, this suspension period that we're talking about in New Hampshire applies to your privilege to drive in New Hampshire. It does not apply to your driver's license. The only entity that can revoke your Massachusetts driver's license is a Massachusetts court, or the Massachusetts Registry of Motor Vehicles. Now, there is reciprocity between the Commonwealth and New Hampshire, meaning at some point in the Commonwealth of Massachusetts, the Registry of Motor Vehicles is going to find out and determine that your privilege to drive in New Hampshire has been revoked as a result of an administrative suspension, whether it be a refusal or a test over. That timing of that notice from Massachusetts of reciprocity varies from case to case. It's usually within 30 to 60 days from the start date of the suspension in New Hampshire, but it can be longer, and I've seen it much longer. There's no real rhyme or reason as to why there's any kind of significant delay from Massachusetts, but it does happen. But if you're a Massachusetts resident, what you need to understand is that you have a valid Massachusetts license. Even after your privileges are revoked in New Hampshire, you still have a valid Massachusetts license until you're told otherwise by the Mass Registry of Motor Vehicles. At some point, you will receive from the Mass Registry of Motor Vehicles a letter in response to the suspension of your privileges in New Hampshire, and that Mass Registry of Motor Vehicle letter will reference the fact that they found out through NDR, that's the National Driver Registry, and literally it's a database where states report to other states notification of revocation of privileges. So Massachusetts cross-references NDR, they see that you're revoked in New Hampshire, and then their response to you is, we found out through NDR that you have a New Hampshire chem test refusal, or per se, meaning you tested over, and then Massachusetts will tell you, as a result of that, your Mass license is now indefinitely revoked. And literally indefinitely means for some unknown period of time. It does not mean forever, but what it does mean is all they know is you're revoked in another state. They're going to give you 15 days. Typically, they're going to say, if they find out, notify you March 1st, they'll say effective March 15th, you are revoked indefinitely as a result of the NDR notice we received about New Hampshire. Indefinite in the sense that your license is revoked until you can prove to the Mass Registry that you're now cleared by the state of New Hampshire. Down in Boston at the Registry of Motor Vehicles, they don't pull out the books off the shelf for every state in the nation to determine what the periods of suspension may be. They just suspend you indefinitely, meaning come see us when you clear New Hampshire. If you're a Massachusetts resident, when you receive that notice with that effective date, that is when you need to stop driving everywhere because you no longer have a valid Massachusetts driver's license. Now, the criminal process in the district court in New Hampshire is a DWI. A DWI is a standard first offense, is a Class B misdemeanor. And that's significant because with a Class B misdemeanor, you can have no jury trial. There is no jury trial. Every case is going to be a bench trial, meaning you're going to try this case to a single sitting judge in any particular district court where you find yourself charged. There are mandatory minimum penalties, which will typically be the only penalties that apply. In New Hampshire, every first offense DWI has a $500 fine. All fines come with a 24% penalty assessment, so the total fine due on a first offense is going to end up being $620. Also, each person convicted of a first offense must complete the Impaired Driver Intervention Program, referred to as IDIP, sometimes also referred to as Community Alcohol Intervention Program, or CAPE. It's the first offender alcohol education program in New Hampshire. If you're from the Commonwealth, you can complete that program at home in Massachusetts as well, and that's always going to qualify for purposes of IDIP. The law is, in New Hampshire, if you are convicted or if you've pled out to that first offense DWI, the loss of license imposed by the court must be a period of at least 9 months. The law also states in New Hampshire that as long as you enroll, meaning sign up for and make a payment towards finishing this class, as long as you enroll in this course within 45 days, the court, upon motion, will reduce your loss of license to 3 months. And they are going to take 6 months off the back end of the court-ordered suspension and reduce it to 3 months. That's just to give you incentive to go sign up for the program. Critical to understand, the 3-month period of suspension, if you have taken a chemical test, is always going to run concurrently with and from the start date of the ALS, meaning this date, no matter when it happens, is always going to be backdated to the beginning of the ALS if you took a test and you tested over. If you refuse a chemical test, and this 6-month suspension is based on a refusal, then the court-imposed 3-month suspension literally is added on because it cannot run concurrently. And now between the two, you're back up to 9 months. If you're a Massachusetts resident, again, this applies to your privileges. And your privilege to drive in New Hampshire will be revoked for these same periods of time. The Massachusetts response, you're going to get a second letter from the Mass Registry of Motor Vehicles. That letter is going to say, again, we found out through NDR that you have a DWI, you were found guilty, and then they're going to say you are now revoked for 1 year. And that is because they treat you as if it happened in Massachusetts, and under the Massachusetts drunk driving statute, a first offender is revoked for 1 year unless they do the alcohol alternative program. Now, the alternative program in Massachusetts includes 1 year probation and an alcohol education class. If you have that type of disposition in Massachusetts, your loss of license is only 45 days. What will happen is initially they're going to take your license or notify you of a 1 year revocation. Once you've cleared New Hampshire, meaning you've served all the suspension time here, served all the suspension time here, you completed your program, you have to do three things in New Hampshire. You have to pay them a $100 reinstatement fee. You must provide them an SR-22, which is a insurance bond because you have to be an insured driver to be reinstated from a DWI, and you have to finish the program. If you've done all three, New Hampshire will issue a clearance letter. That clearance letter is based on the completion of an alcohol program. So when you go back to the Mass Registry and you show them that New Hampshire's cleared you and that you did a program, Massachusetts will reduce the 1 year revocation to 45 days because you did an alcohol program, and at that point the 45 days is deemed served, and that restoration letter clears you from not only the indefinite suspension based on the ALS, but also the suspension based on a conviction. And then your Massachusetts license, once New Hampshire has cleared you, will be restored fully. Most importantly, if you're a Massachusetts resident and you remain in NDR, whether it's for purposes of the administrative suspension or a conviction, there is no right, absolutely no right to a hardship license in Massachusetts because you are suspended in another state. The Massachusetts Registry of Motor Vehicles will not consider you for a hardship license.